Do I have to do something with sign in? Do I have to sign in?
To the bottom, down at the
Unmute.
bottom there. Thank you.
Can you hear us?
Now, can you hear us?
No, you're just
Yes.
muted it.
Yes, sorry about that.
Yeah.
So we have a hearing at 7:10 before our conversation about your application, subdivision application, okay? So we're first gonna start with Devin Lynch's continuance hearing at 7:10.
3 minutes.
In 3 minutes, it won't take me 3 minutes. Ariane come in about about the village, project up here on the. And our subdivision regulations don't meet, they right now have a limit. Well, wrote Will Colgan and he's working on that, and they're gonna change that in the zoning regs along with some other things like village district boundaries that need to be changed in our the zoning regs, and then they might do a select board interim adoption of just the subdivision regulation before the whole zoning regs go for the town.
Okay.
So that they can file an application process. And he said that, yes, limiting the amount of lots is not legal by state statute.
Oh, okay.
All right, there we go. That's my update.
Okay, well, I didn't get any of that.
Well,
This is the
Okay.
problem, I'm not gonna be able to pay attention
And, well, you don't have, well, I mean,
hopefully that is recording now.
we
Yes.
do have, yeah, so we do have the recording that minutes can be taken
Yeah.
from, or maybe you could.
And that's how Christine was doing it, by listening to the
Yeah.
recording.
Let's find that one.
got one more minute.
You have it right there, right?
Yeah, that's, yes,
This is the whole file.
yeah, Karen got all. Yes. I think that's all stuff we've seen before, right?
Yes,
This-
this is just
This- the
This
updated-
is the new updated one, right here, and this is just, that's the denial part, it's just all the information.
right, and then there's the letter of the things that we requested for them to submit.
Mhm.
Attached to this, right? Let me pull that out.
Someone very low. Okay, it's 7:10.
Great, so our first item. We have a continuance for a public hearing for Devin Lynch's appeal for a variance of setback in Forest and Agricultural Land District. Okay, and this is anybody who's gonna speak on this hearing, at this hearing, I will need to ask you to affirm. Find you're gonna have to swear you in. While we wanna speak. Right here, so all we wanna speak on behalf of this hearing, please raise your hand and say, it's oath, take the following oath. I hereby affirm that the evidence I give in the cause under consideration shall be the whole truth and nothing but the truth under the pains and penalties of perjury. I do.
I do.
Affirm? Yeah, great.
And do we have anybody
Oh,
calling in that's,
Devin, can you mute and can you affirm as well?
Do you know that, Devin?
Yes, it's his phone number listed on the application.
okay, yep,
Thank you.
Devin, do you intend to speak on your behalf today?
Still muted.
He's on the phone and I don't, it's star what to unmute, what does it say on the direction? Shows him muted.
I'm sorry.
I might be able to do the unmuting here, I'm not sure. No,
You could ask to unmute, maybe is all you can do.
Anybody know the phone code for unmuting your?
it's on here.
Yeah.
Oh, there we
I
go.
got it.
Yep, you
Okay.
got it. You can hear you.
Can you affirm that you'll speak nothing but the truth under pain of perjury?
I do.
Okay, great. So we did receive your amended application with a redrawing of the building that you'd like to build on the property. And did you?
Yeah, and the measurements and all that on the previous one, I don't know what happened, but they were not correct, so I have a revised one of those in there too.
Revised that you've submitted already, or you have in
Yeah.
addition? The
No,
one,
I already handed that in with my updated application where it shows 50 feet, all the setbacks and all that.
right, so I see that one here. Did you make all those measurements yourself?
Yeah, I measured everything, got 100-foot tape. Yeah, I did all the measuring myself, all that. Yep.
Your map doesn't show where the flood inundation line is on your property, and so that's a concern because you can't build in the flood inundation area of your property. So that would somehow have to be designated on a map. And I would think a surveyor was gonna need to do that because the map that we have with it doesn't have an exact footage away from your property, or is this right here? You know, so we need that information as well.
Yeah, I had talked to a surveyor and they said that you guys should have where the floodplain is from the road.
Special hazard area, yeah, well, we don't have any map, do we have maps of the town that lay that out, Karen?
There are online, they're maps, but they don't have measurements.
Okay,
So it needs to sort of be looked at by, someone more professional than
us,
us, and
Yeah.
Ned Swanberg has been helping other people, you know,
and Ned works for the state?
Yeah.
And what does he do?
floodplain manager.
Okay,
Yeah,
This is Adam Oakeshield. At the last meeting, the board requested that the applicant retain a surveyor, and the surveyor himself would prepare a map
Yep.
that showed all these boundary lines, the floodplain, the setbacks, and the proposed structure.
And the, water and septic
Had
as
to
well.
be an engineer,
an
Yes,
engineer.
and he had to show proof that he owned the property.
We
Well,
had,
his-
yeah, that was my other question. I sent you twice an email and a letter, Devin and Karen, since she reached out with the list that we had requested at our last hearing. And,
Oh, I guess I
none of
didn't
us heard
receive
back
that. I
from
didn't-
you.
Yeah, I didn't see an email. It said there was an attached file, but I didn't see any attached file.
Well, it was just a letter straight in your email. It said it was below my hi Deb, it was just a letter, there wasn't an attachment. It was just like, hi Devin, you know, here's this list of things we need for you to bring to the hearing today. And I also mailed.
Okay,
a
well,
copy-
I guess I didn't get nothing in the mail, and I didn't see that in my emails. So
All right, well, I see the one.
I do have a septic designer. I've been working with Chase and Chase. They're actually drawing up the septic and all that. And he actually does do surveying and all that. I just wasn't aware that I needed to have the surveyor done by now, I guess.
I
Yeah,
will point out that it was in our minutes, from the meeting that we wanted an engineer or a surveyor, but it was not in the letter. It just says,
survey for site plan to include.
right. It could be a drawing,
No, right.
so. Anyway,
Well, so if you've got Chase and Chase under contract, I think that he's gonna have to, do a survey of your property and give us a surveyed map of all of what you've drawn on your proposal and your site plan.
Okay.
'Cause we can't,
It will have
make-
the septic, it will have the septic on there and all that too, I'm assuming.
correct, yes. Correct.
I was
Okay.
confused, Devin, by the last discussion. It said that, you said the trailer that's there now is not using the septic system? Is
No,
that-
the camper has its own septic. It
Okay,
has its own holding tanks and all that.
okay, thank you.
And then you're having that pumped out?
Yes.
Into what?
Into what?
They pump it in their truck. They come and they hook a hose up to it and they pump it into their truck and they take it with them.
And you're supposed to show receipts.
Well,
Do you
no
have-
one mentioned her. I did actually send one receipt of when I had them come and pump, but
Okay, well, it'd be good if you could submit some receipts for that, so we know that that's actually what's going on right now. I also know that
Yeah.
the select board has concerns and are, about the property as well, so, it would be
Okay.
good to submit those to the select board and to the DRB, that would be helpful.
okay.
Okay,
What company's been pumping?
pumping, what company's been pumping?
It's in Waterbury. Oh, that's her name.
They'll have historical receipts too.
Okay.
What the hell was it? I can't remember exactly right now. What the hell was the name? I just did it not long ago. It was 400 something bucks, but
Well, we find those receipts and send them to us, and if you can't find the receipts, please email us.
no, I can find the receipt, or I can just have them email me a new one. That's no big
Yeah,
problem.
yeah, right, and then forward those to Karen and the select.
Okay.
Good,
Okay.
great, good, all right. Well, I don't think we can make a decision based on this information tonight.
I thought you said the last meeting, all this stuff had to be here for this meeting and a final decision would be made November 13th. Don't start backing off.
I have to look at the minutes to confirm, which I don't recall.
Look at the
I will
minutes, please.
look it up.
Yeah, he was online, he heard that he had to have a surveyor, he had to have an architect.
Well,
And
I
he had
heard that
to-
they wanted me to have that done. I didn't hear that I had to have all this done within a month of the last meeting. I mean, it takes longer than a month. These people they're booked out. I mean, you can't get someone to just drop everything and come within weeks. I mean, you got to set this stuff up with people.
Let's not argue about it, and let's just have, look at our minutes and see what our minutes say. That's why we have minutes.
Right. Are you looking that up, Seth?
I am, I'm just trying to see,
That was a month ago,
yes.
that was the,
It was in September, wasn't it?
was it the special one, the 24th?
Yes.
We had to have it on the 24th, because it was the 24th.
But that was September,
Yes.
so a month and a half.
Right, it wasn't the, right, because we had to. So,
Not seeing the minutes on here.
didn't she say she posted them
Oh, I have.
in an email? Give them in an email, don't you?
No, I opened, what was it, the 24th?
Yes.
Oh, wait, no, I see,
Okay.
I thought that was a link to the video, never mind, I see it, okay. That's the 24th.
That's what we were saying, yes.
Yeah. Not in the minutes. There's a continuation. Then, for today,
And we requested this information.
Yep.
That I know we did.
Yes,
You have
yes.
not gotten it.
no, we have not got,
But what we have is,
We have
an applicant who said that he's in touch with Chase and Chase and that they're drawing up
Says he's in
design.
touch. And I wanna say something about the septic, okay? I have a camper. A camper will hold 4 days max, water and sewer. If he paid the pumping company $450, it's going into the septic in the ground and he's having it pumped from the ground. It's not being pumped from the camper. So
Ma'am,
he's using the septic.
$450 wasn't one pumping. That wasn't one pumping, $450.
And
That's
was
when I
it, was,
paid it.
was it pumped directly out of the camper or out of the ground?
Yes, directly out of the camper. And the difference is we're not here all day. No one is even on the property all day. This property has people who sleep on it. That is it.
No, your lady
We don't
friend
sit
is,
around all day. We ain't there all day. We ain't
Was-
filling up the thing in 4 days. If you're filling up a camper in 4 days, dude, you must be in there all day, every day.
yeah, okay, but this is outside of our purview
Yes,
here, this is
thank
more
you.
of the select board, purview as far as that goes, so. Yeah, but my recommendation was that we offer one more continuance to December to get materials. We'll send this, make sure it's clearly stated that we need an engineered survey. And if we don't have that, we will be making, we can make final determination on 10th December, so that would be my recommendation. Adam.
This is a question for the board. Can it be required that anyone who wishes to present any information at the next meeting appear in person? It's easier to have these conversations in person, I think.
I'm not sure that we can require that. I don't think we can.
I don't think we can.
It'd be nice if Devin, you could appear before us, it would help a lot.
Yeah, I don't mind. I just haven't really known where to go or any of that. I have no problem with that at all.
All right, well, what would be great is if I could make sure you receive this letter with the list and we can make a motion that all of this, you need to have proof of, you know, your septic pumping and we need you to have.
The
at least
surveying
survey,
and
yeah.
the septic plan.
If it's not done, at least a letter from Chase and Chase saying that he's working on it, things
There's a
that
contract. Okay.
show
Yep.
that you're moving forward with the requirements to get a building permit.
Absolutely.
If it's not there prior to the hearing, letting us know ahead of time so that we can let folks know that they don't need to be here.
So do you have a mailbox on your property?
Yep.
If I was to go up there and leave this in your mailbox, I would need.
Oh yeah, I'll get it.
it. And then I'd like you to contact me and let me know you received it, all right?
Yes. Yep. I
Okay.
can just send a copy of it or whatever to your email, let you know I
Yeah.
received it.
Yeah, my email will be on it, okay? Yep, good,
Okay.
all right. So why don't we make a clear motion of our next step?
Oh,
Go ahead.
that can be debate after your motion, I guess, but.
Okay,
So I have that started to make a motion to
Yeah, I
continue.
can turn that into a motion for,
Can I just ask one?
yeah,
I think it's really, I think one of the primary concerns of the neighborhood is the septic and how it's being handled, making sure nothing's going into the river. But I understand you're gonna ask for proof of septic pumping, but you need the frequency of that because the tank is only so big on a camper.
exactly.
And that camper has been historically connected to the septic on site.
So the precise dates.
So either there's a lot of receipts to show, or there's communication with the septic company to clarify that they indeed did, you know, can they tell us with certainty that they connected to a camper, not the in-ground septic system? And that should go back to February 1 of 2021, or as long as Devin is not on the property.
2021, how long's Devin, how long have you occupied the property?
I've been here, I think it's a little over a year. Not quite a year, maybe.
Well, not Miss
My
Sarah.
mother's just been passed away for, I think it just hit maybe a year or close to it, so.
So February 23, you're thinking, or fall of 23?
Somewhere around there, I believe.
And I would like
Yes.
to say something maybe before you make the motion, because maybe you want to include this.
Yes,
My understanding was there were kind of three main things. There was the septic information that is needed, the survey and
Ownership.
a better map.
Mhm.
Because even the one we
Yeah.
see here is not clear.
right, so that's surveyor would do
Engineers.
that, right?
And a third thing was for him to apply to build there, he has to show that he owns the property. That was a third thing that we discussed.
Unfortunately, my understanding from the town lawyer is that because his mother, his mother's estate, that the courts grant the heirs of the estate the right to occupy. And our zoning regs don't specifically require that the applicant be the owner.
Oh,
I contacted our own town lawyer about this.
Michael Terran.
Was it Michael? Yeah. Yeah, because it was like, wait a minute, what am I supposed to do as the chair of this DRB, and how are we supposed to navigate this very complicated, not clear situation? And he said that the courts have generally, every time they have not ruled, they rule in the property owner and the estate in favor, not for that, it's, it's what I was told.
Okay. So I'll make a motion for continuation to the December 11th.
I'll second.
December
11.
December 11th, yeah.
Okay,
With all the conditions we discussed. We'll
and that,
take
And it's at the
including
same
the
time?
ones.
including the engineering survey,
Say it again?
same time, yes.
Yes.
It'll be 7:10,
Yeah,
will be the hearing.
and I will bring this up to your mailbox, and then I'll my email with it so that you can reply, tell me you got it, all right? And any receipts
right.
you receive before, we'd like some for the hearing, it'd be great, anything you can give us
Yep,
before the hearing, okay?
yep, I will
Survey.
do my best to have all of this stuff, on December 11th.
All right, thank you.
Yeah.
All
All
right,
right,
so
thank
I
you and
think
have a great-
that hearing,
did you vote on his motion?
No, we haven't.
Oh,
no, we have,
I
we always.
seconded.
And then any more discussion on that?
What was his motion? I forgot.
will that be the final
That's right, that's a
Decision
good discussion about that,
date?
well,
Because we sort of thought
this was the.
this
Uh,
was the
yeah.
final decision date.
Yeah.
I know that was stated, even if it's not in the minutes.
Sorry about
We,
that.
we all were
We're
here.
gonna be trying to be very clear about it this
Yeah.
time.
Okay.
Yeah.
All right, so I'd
Make sure
say,
that's in your minutes, please.
well, if this is
I'm
much,
sorry, I don't know your name.
Gary.
There.
yeah, so what we
could-
need,
I could state.
yeah, say, go
I
ahead.
could state an intent to make a final decision in that hearing.
What's that mean? It could
It means-
still be another meeting.
It means that you can't always know what's gonna happen, but that's the intent. That I personally had the intent for that, I don't know, I'm speaking on behalf of everyone. It's not that I'm really gonna put in a continuation, but that is the intent. Then given ample time. There was some miscommunication here, we're clearing that up. I think everything's clear now, we should be able to make a determination at that time.
Well, I think requiring the proof of the septic pumping and proof that an engineer is working on the survey and.
But we need to see that.
Well, you need
Yeah.
to see the
We
survey.
need to
Yeah.
see the survey,
I don't
We need-
wanna know that they're working on it. I
You
want
wanna see it done,
Yeah.
all right, so it
Yes.
needs to be done, all right, I think you heard that, Devin. So get on Chase,
Yeah,
if they're doing that
yeah,
work.
well, the survey part and the mapping of all that I'll have done, but I don't know if I'll have the whole design of the septic done by then.
Well, what?
The survey said he'll have it
No.
done.
He's not sure they'll have the
Septic is
whole
fine.
septic, as long as they have the locations for that, they should be able to do
Yeah, we
that.
really, and
They might not have the final drawings for the full septic system, but they should have the site map.
they really need to include
Yeah,
the
site
boundaries
plan,
of the special flood hazard.
And normally I would think Chase and Chase wouldn't put the structure on the survey, but this survey needs to have that.
Yes.
Right,
It
it
needs
needs
to
to have the
have
building.
The building and the setback distances,
Proposed
all of
locales
them in every
location.
direction.
Yeah, and if it's unclear, or Devin, if you're unclear about that, you can have Jason Chase
Yep.
reach out. And Karen
Okay.
might be the person to talk to.
Chase and Chase has done a lot of work in Plainfield and they're really
Yeah.
know about all the rules and regulations, so they're usually really spot.
I'm just saying, if there's any lack of clarity in what they need to show, is it all right to say they
Oh,
can reach
Chase
out
and
to you?
Chase usually contacts me.
Okay, great.
Great, all right. So we have a motion.
I just had one more question. You guys were talking about a guy, who could do the floodplain thing.
Oh, Ned,
If he's gonna have.
Chase and
Chase
Chase.
and Chase, they also do that.
Oh, okay. Okay, yeah, that's what I'm already working with then. Okay.
Great. Well, so we have a motion and a second, any
Yeah.
further discussion? Then all in favor of a continuance of this hearing to December 11th at 7:10, say aye.
Aye.
Thanks for your patience, everybody.
Thank you.
Thank you. Thank you.
Thank you.
Wow.
For the next one, the next,
One disappointment enough.
All right.
Yes.
Don't feel involved today.
hello. So our
Hello?
next, yeah, we're
You're
done.
all set,
Devin.
Devin, you can hang out if you want, but you don't need to stay on.
Oh, okay. All right, thank you, everybody, and
All
have a
right,
good
be in
night.
touch, and we'll be in touch.
Yep, I will. I will.
Thank you. What?
I agree.
All right, so our next discussion, it's a discussion on an application we got from the estate of Robert or Barish for a subdivision, and then the applicant is Paul Gillis, the executor of the estate. And we have really, we're here, my understanding is to go through the regulations for a sketch plan. It's a major subdivision, and in our regs, we have to have a conversation about that, and then we clarify what's needed, and then we would schedule a hearing. Yeah, and you must be,
I'm Heather Devine,
Heather
I'm
Devine.
Ronald's attorney.
yes.
So are you saying the hearing wouldn't be tonight?
This is not a hearing, yeah, this is so with a major subdivision, we have this kind of informal conversation with interested parties to make sure that you know all of what is needed, and then we schedule the hearing, and then all the neighbors and the butters are informed, and then we have a full hearing. And if you're prepared to go to hearing next month, then we would schedule it for next month. If you need more time, we would schedule it.
But I know I have some confusion about.
Me too.
About this one, so.
Yeah, me too, and so I mean, being the executor who submitted this, would you like to give us an overview of what's
Tell me
happening?
what your name is again?
Heather Devine,
Heather.
excuse me. Yeah, I ended up
Excuse me.
sending,
Can anyone see me?
Yes, we can.
Yes,
I
do we need
can't
to-
see,
he can't see you, would you like to sit where he
I
can
have
see
nothing
us?
to- I can't sign on to Zoom.
Don't need to
We don't have the
because it's
roaming.
not here.
Right, yes, camera thing.
No.
I'm gonna
This is-
jump in. Charlie, you don't
Have-
need to sign in. You're in here with us right now. We can all hear you and see you. And you don't need to sign in at all. I'm sorry to interrupt everyone, but I heard him ask earlier and none of us knew how to answer right away. So you're in here, Charles. We can hear you loud and clear. Go ahead, everyone.
So we were gonna give Heather the floor right now to explain the application, and then we will take questions and comments and go through the subdivision rates.
So I actually sent Karen two maps, they're almost exactly the same, but we should be looking at the second one. See if that's the one that you have.
I looked at both
Both
maps
of
and they looked exactly the same to me.
Yeah. The only difference is that we're planning on, so Charlie and Andrea Barish currently own this little triangle.
Yes,
And we convey these parts, we're planning on just merging that into one, so it'll be
Okay.
one instead of three separate parcels. Upon subdivision, but we had to show it like that, so you could see the part that's owned by the estate and the part that's owned right now by Charlie.
Okay.
It's like 10, and what's the date on it? I wrote the date.
Yeah, I think it's,
These don't have date on them.
There's 10-3 and 10-15 that I have.
Maybe we wanna add them to these.
this is 10
Oh.
October 15.
That's 10-15.
So that's not updated.
That's up
Okay.
there.
Okay,
So
so,
this here,
yeah. Do you wanna give us a little overview, what
So-
this is about?
yeah, so the estate owns that whole parcel. And it's part of the distribution of the estate to subdivide it into the smaller lots and convey them to the beneficiaries. And that's all we're doing is subdividing it and conveying it to the beneficiaries. So we need permission to subdivide into those lots. I don't think that we need anything else like a stormwater plan or sediment erosion plan. We don't need any rights of ways for driveways, so I think most of. I've asked for variances, I think most, or Karen said that's how I should do it, that most of the requirements don't actually apply, all we're doing is just
Right.
subdividing into parcels so that we can convey it to the individual beneficiaries.
Yeah, I don't know if you've experienced this before in a subdivision that's not a build, there's no intent to build. Okay, because my tenure here, I've been through a number of those.
Okay,
so the red lines are new divisions or
Yeah.
they exist?
so this shaded bit, that currently exists.
Yeah.
And that's owned by Charlie and
Right.
Andrea Barish. Everything else is currently one parcel.
Oh, so these are all
Yeah,
new
these
lots?
are all new, so it's,
This was not, though, this is outside, this is
That's outside.
owned by somebody else.
yeah, that's owned by somebody else.
Okay,
So what would be new, and I'll go ahead and write on, we'll have numbers on it with the next survey.
go ahead.
But so what would be new is you'd have these two lots at the top, 2 5-acre lots. And then this is all gonna be one lot above the river or stream.
Okay,
To there will be one lot, that'll be 3,
I see 5,
and then this
1, 2,
big,
3.
So this will all become one.
Yeah,
Okay.
Yeah.
Okay.
yeah. And then this big area here. That would be 4. And then this area here
okay.
is the 5th lot.
and have you seen this map?
I'm not sure. I've seen the map that I have, but I haven't seen this.
Are you Janet? I did email that to everybody.
Yes, I have seen that map. That's not the map that we have approved as.
And did you send us another map?
I did.
Yeah,
And how does it differ?
Yes,
The map that the surveyor prepared and the map that Heather sent to all of the heirs and beneficiaries to approve had a right of way on it. And when this map appeared to the town, the right of way had been removed. And I don't know if you're ready for any discussion, but that's the difference of the map, is that this map is not what has been approved. And I have a letter from Heather saying that the right of way was going to be codified in my deed. And it's
Right.
not on this map. And so that's a
Right, that's
concern
what
for the
that-
town, is that you're looking at a map that is not valid. It is
Well,
not.
right of ways do have to be discussed as a part of the hearing. Is my
Yeah, the
recollection.
estate, so the backstory on that was, there's a will, and then there was a stipulation that kind of modified the will. And part of the stipulation was that the estate would create a subdivision survey. So first they kind of had a plan, but this is how we're gonna subdivide, and then the stipulation authorized Sunwise Surveying to create a survey. And so Sunwise Surveying created the survey, and I emailed it to everyone. It did propose an easement right here. But it wasn't part of the stipulation that there would be an easement there. And so one of the beneficiaries, the one who's supposed to receive this parcel, objected to the easement. So that, and this parcel does have road frontage, so it's not required. I didn't see anything in the subdivision regulations that would require the easement, so we took it off. I don't think that it's part of your decision making. The beneficiaries are not applicants, and actually, except for Charlie, they're not butters either. I think that if there's a problem with the map and stipulation, it would have to be through the probate court. What's happening here is just the estate, which is the only owner of this parcel, is asking for this subdivision. And so I think the only question before you is whether this proposed subdivision fits your regulations.
The problem is that if the DRB grants this subdivision, you are creating a parcel of property that can never be developed. You are creating a landlocked parcel. Now,
Yours.
what Heather is saying is that I have road frontage.
Yeah.
That is near the Cubby lot.
Can I see?
It would be $1 million to build a road across, and it would go across complex wetlands and 4 different water lines that are assigned to people for decades and decades. We have an engineer working on it that it can never be permitted to even create a road if I had $1 million. It is not my dad's intent, nor is it the intent of a DRB and a town to create a landlocked parcel that can never be accessed. And the way that it was written and the way that it was proposed to all of us and the map that we approved that went to the court asking for the court to allow us to move forward with the subdivision had a right of way so that parcel could be accessed. And everybody signed that map, including the landowner that has the driveway. So that was approved by all parties. How it came to be removed is between Heather and one of the heirs. It was never discussed with any of the other heirs, and the problem is, this is the map that everybody signed. Nobody signed the map that you're looking at.
May I see your map, please?
Yeah, and I sent one to you.
Yeah.
It's easier in color,
Here,
mine's in
it's
black
right
and
here.
white, but you're
We
welcome.
got it right
This used to be,
Oh, so this is.
Yeah.
Okay.
Here, it's not as clear with black and white, it's clearer in color.
So
So that was the map that was sent out by the estate, and
Here,
we have a letter saying the estate approved the right of way and that would be codified.
Yeah. that's the.
So again, it's only the estate that would have the authority to ask for a right of way. I looked in your subdivision regulations and I did not see anything that would require a right of way so long as there's road frontage. I told Janet's attorney that if they wanted to challenge what the estate was requesting, they could do that in the probate court. I think that's the appropriate place to do it and figure out. I disagree with Janet's factual representation. And I don't think it's meaningful, it's productive for you guys to consider that. Because it really would be under the probate court whether a right of way would or should be required.
Well, just my
Can I
thoughts.
just,
Can I
Heather,
go
can I
ahead?
just say something,
Yeah.
Heather?
No,
You just
I
said,
don't think we need to have an argument.
well, you just said, and I said something that was false, and I wanna be sure that what did I say that was false?
Well, I said that in addition to that, that I don't think that those facts are relevant to be talking about right now, so.
That's
I don't
fine, but you
think
said,
we
that's
should
not
get
what you
into
said,
it.
you said I said some falsehoods, I just wanted to clear up for the DRB if I had said something that was incorrect.
I don't think we need to.
Excuse me, everyone, I'd like to speak for just a
Hi, Mark, would
moment.
you like to speak?
May I?
Yes.
At the right time, I'd like to speak. I'll wait for the
Yeah,
board
why
to tell
don't
me
you
when that
speak
is.
now? Go ahead.
Hi. My name is Mark Barish. I have no interest in displaying a conflict in this room. My family has been blessed with a relationship with this town. Some of you may know that my brother was the moderator of the town meeting for decades, that my sister herself sat on the select board after her husband, after my father. I painted the town hall of Plainfield when I was in 10th grade. We don't need to have an embarrassment here. Heather is correct. If Janet wants to challenge this, she can take this to court, and that is her prerogative in America, and that's fine, but there's no reason to have a big discussion here tonight. I can clarify for all of you that what happened here is that there was a will which stipulates exactly the boundaries of the property that Janet's referring to. There can be no dispute about our father's intent to deed that particular parcel. The boundaries are clear. Then there was a stipulation which was then put in front of Justice Kilgore, and it is now so ordered, and it defined these boundaries and confirmed them, and it never mentioned any right of way. My brother himself told me, as did my son who's here this evening, that he had never heard anything about the right of way until he saw the emails back and forth that there was suddenly some question about the right of way. It was never mentioned in the probate court. It was never mentioned in an expensive mediation, and it is not included in the stipulation. Unfortunately, the surveyor, who will be brought to testify, obviously, if this goes to court, made a decision on her own to add this right of way, and Heather placed it into the map. She sent it. The one thing that I can say, Janet, that was incorrect is that no one ever signed this. I signed a stipulation, but I've never signed this map. What I did do is I said to Heather that the boundaries of the map, and you were not copied on that email because I can't write to you for my own reasons. So, but on the I did say to her that the boundaries of the map appeared correct to the stipulation, and they are. But I never approved or knew of the right of way until one Friday evening in Florida when I looked at this, and my eyes are very bad. Some of us know. And so I noticed this little green line, and I immediately, and Heather, this will be in the records of our phone records, of course, because I called you immediately. It was about 5:25 on a Friday evening. And I said, Heather, I just saw this thing. What is this? And she said, oh, no, that's something that Lisa put there because she thought it was a convenience. I said, well, that's very cute. But as Janet just said, it would cost her $1 million to build the road. No one's mentioned how it would devalue the property that my father left to me, which would divide that field. And by the way, it was you, Janet, that clarified that that field is the only 10-acre lot on my property to be bequeathed. That's why you got the 10 acres of Charlie's land and I'm not getting land in excess, because you clarified and you were correct that I had a 10-acre lot. That is the only place it sits, is where that right of way would have gone. So we're all very chagrined that this error happened. It was a clerical error and a misdeed by the surveyor that Heather unfortunately inadvertently put in, and I did not notice for many weeks. I approved the boundaries. This I will never approve. So Janet, again, if you need to go to court and speak to the courts, you can do that. But there's no reason to drag the town through this. And Heather and Janet, both of you, and Charlie, Nathan, thank you guys all for letting me speak. And that's really, I think, all I have to say. There's no reason to go any further. It's up to you, Janet. If you want to try to litigate it somehow, it's up to you. But I can't approve it because I can't have you on my property, and I can't have you building 5 houses over there and having 5 families driving through it, or maybe doing agricultural work with tractors coming through for the decades to come. Our father left me that property unadulterated. You know that. You know exactly what his intent was. So does Charlie. Thank you all for letting me speak. Thank you all very much for letting me speak. Thank you.
So this was all approved in July. And Heather, I don't believe put it on, I think the surveyor did, is my understanding. And that was the map that was sent out. So that's what everybody signed, including Mark. The other concern that I have for the town is that one of the property owners for the boundary agreement has not signed the papers yet. She is not comfortable. And so if you're looking at trying to approve.
Darlene Covey, that one, I read about that.
So, I'm just trying to make it better for the town so that you don't spend time on something that is possibly, as Mark said, it may go back to court, as Heather said, it may go back to court. That would be a long process. And I was hoping that wouldn't happen because it made perfect sense that when in July it was approved, the executor said it's there, it's gotta be in the deed. It isn't that nobody saw that. Mark is saying he never saw it. It was on the map. And I specifically asked Heather if it needed to have a specific statement that says, do you all approve the right of way? The letter from Heather said, no, we don't need approval of the right of way. It will be written into your deed. So I don't know how it changed and how you go about
It's,
then.
it's simple, Janet. It's so simple. And I don't want to interrupt you. I want us to be able to converse if you'd like to, but it's very simple what happened here. The thing got added without my knowledge. I'm to bequeath that property. Charles is here in the meeting. Charles, could you confirm for the meeting whether you ever knew about the right of way in the summer? Because you confirmed for me twice now that you were never aware that it was put there. And Marcel, my son Nathan is here. He was never aware. That's who this property is really for, by the way. So Janet, I'm sorry that there was a clerical error. I'm sorry that you got excited. You said in your email to Heather that you were very happy to see it there, that you hadn't expected it. It was very clear in your tone that you were happy to see it there. And then you mentioned what you said tonight, that it wasn't your father's intent to leave you that property, but that, I'm so sorry, is rhetorically silly because that's not meant rudely. It's meant respectfully, but bluntly, it says it in the will that this is your boundary and that's what you get. So I'll stop now and I'm really gonna stop for the night and let you finish your meeting. Thank you all very much. And thanks, Janet, for letting me speak. Go ahead, guys.
So my reason for coming
Questions
here
you guys
was to
have?
I think Janet
Yes,
was
we get-
speaking.
Yeah,
My only reason for coming here was not to create any discord. It was to allow the DRB to make a decision and not use unnecessary time if it's going to be in a continuing situation. And so that's really why I was here, is the two issues is that one of the landowners has not approved the boundary agreement. We met with her, I thought it was okay, she has not approved it, she has not signed the paperwork, so you don't have a boundary agreement that is signed by one of the landowners, that has to be completed.
okay.
And I'm not sure what we need to do to make that happen, but that's one issue, and then the other issue is that the map that you were presented is not the map that we all approved in July, so maybe there will be more issues there. It
Okay.
doesn't sound like we're gonna make it simple, so we'll just do what we can.
Well, it says here supporting documents for preliminary subdivision application, a legal description of any proposed covenants and or deed restrictions which are intended to cover all or any portion of the subdivision, a description of the proposed homeowner association, but that doesn't work here. The erosion doesn't, because that isn't also a part of it. Road frontage is something, especially, you know, even if it's not a I mean, we consider road frontage.
There is one problem with the road frontage for the parcel that's going to Mark. This is actually insufficient road frontage, but I don't think there's anything we can do about it because this is owned by somebody else and this is owned by somebody else. That driveway's been there for a long
Forever,
time.
right,
so-
correct, right, so
Yeah,
it's,
but
well,
other than that, I think.
so this is already an existing
That's already in
boundary.
existence,
Except
yeah.
you're saying, we did read that this isn't clarified,
Well,
No,
no,
it's
so
this.
skipping ahead, it's actually this.
oh, Darlene Covey.
And
Up
I
there.
don't know if Darlene has had other conversations with Janet, but Darlene told me she is comfortable with this map. The reason we haven't, and with the agreement, the reason we haven't signed it is I wanted to go through all the processes, the water and wastewater permit process, this process. And have just one survey at the end that we record and then reference back for everything.
Yes,
So I was gonna get through everything, get the survey, and then have the boundary agreements referring to that one survey. So she told me that she's comfortable with this and with the agreement, but we haven't signed with her or with Charlie Barish for also doing a boundary agreement there.
yeah,
To clarify that, we have not asked for boundary adjustments because we're not, we don't understand them to be boundary adjustments. When the surveyor went and looked at the property, she said that the deeds just couldn't be on the ground the way they were described. And so this isn't really a change, this is an agreement to clarify what already exists. So that's the process of that.
Okay,
And that's why we don't have to do it that way, but that's why I thought about doing it that way, of doing the agreement along with everything else once we have final survey.
So go ahead, sorry, I have a question.
I have a question about the road frontage on, I assume this is Fowler Road.
Yeah,
So there is road frontage,
Oh, sorry.
wanted to talk to Janet.
sorry.
Road frontage
Yes,
there.
but it is inaccessible and it cannot be permitted because it goes across
Oh,
complex
that's where
wetland
the,
and it goes
okay,
across 4
okay.
water lines. And so what has happened is without that right of way, it creates a landlocked portion
Right.
that can never be accessed and developed. I can start walking at Cubby's, and I don't know if you've ever tried to walk through those woods in that swamp. I can try walking and I may be able to set foot on that. It can never be used and it can never be developed.
The surveyor wanted to walk out.
Okay.
Yeah, and the surveyor, actually, she was looking at the Cubby line the other day and Darlene has a horse that's 30 years old. She wanted her to put the horse in the barn and turn off the fence, and she said, I can't. And she said, well, I'm afraid of the horse. And Darlene suggested that she walk through the woods, and she said, nobody can walk through those woods. He said, I can't walk through those. So the other reason that I came is that the DRB probably does not want to create a landlocked parcel in the town of Plainfield that can never be accessed.
That's what,
That's gonna
that,
be my question, and Karen, I'm just curious, we haven't had one of these, well, I've been on the board, I know within the subdivision regulations that say, you know, one of the goals is to produce usable lots, and so I had a question whether or not there was any intent to develop these lots, and if there is, then
So,
there needs to be consideration of that.
well, if you go to your zoning regulations,
The new zoning regulation,
no,
yeah,
to the regulations that we currently have.
yes,
For the 2011 zoning, you have to have either 300 feet of road frontage.
frontage,
And if you don't have 300 feet of road frontage, and it doesn't say whether it's passable or not, you would have to have a right of way. And Heather and I have talked a lot about the right of way, because the original map, I didn't know that there was 300 feet in that piece. So I was saying that if they didn't have sufficient road frontage somewhere, it would need to have a right of way somewhere to access it, because if you don't have 300 feet of road frontage, you have to have an approved right of way.
but if it's not sufficient because it's going through a wetland, then it's not a sufficient 300 feet.
But that, we never talked or defined that, and we do, I mean, and there are. This isn't really landlocked from the set that does have road frontage. From the regulations. Landlocked means that it has no road frontage, theoretically, like I own a 75-acre piece with no road frontage. So, you know, I have right of ways to get to it, but it doesn't have road frontage, there's no 300 feet anywhere. So I think landlocked, and I don't know the legal term, but we wouldn't, in the past, we wouldn't have considered whether the 300 feet was passable, because typically.
Well, if the intention is that it's a buildable lot, then you would think the intention of the 300 feet would be that a road could be put
Remember, they're
there.
asking for all of those variances,
Right,
which means.
It would be a buildable lot. And it is one of the few places on what I was left that is not swamp. And
that is what?
that is not swamp and might be buildable. So the 300 feet of road frontage has already been deemed unbuildable. And it deemed a complex wetland and it could never be built on. So the only piece that could be developed is that portion off to the right of the driveway. And it can't be accessed from the other side.
right.
So as I said, everyone, Janet, if you need to take this back so that the courts can make a decision, you can do that. I can't agree to the right of way under any circumstance, but if I'm directed by the courts to do so, I will certainly do so. Charles and I discussed briefly that you could also build an easement from your property across the brook to your property in the top left corner. And if you want the board to understand everything, the reason Janet is getting those 10 acres in the top left corner of the map is because the will delineated that she and I would each receive a 10-acre building lot. But she claimed that she didn't have one in this land, no 10-acre building lot. And so it was acquiesced that Charles would give up those 10 acres specifically so that she would have two, as it turns out, 5-acre building lots, greater value than 110, but that's fine. And she has that, and she should. The other point was that I would not receive an additional 10 acres. I didn't need to, because the field that she wants to bifurcate with this right away is a 10-acre building lot. It can't be done on the other side of my driveway if you look at the map, because there's only about 7 or 8 acres before the barn. But on the side that she would bifurcate with this idea, you could put 10 acres there because you'd have the field and the woods leading up behind my shed. So it is possible to do there. It's the only place it's possible to do there. So this can't be done anyway with maintaining the fact that she got the 10 acres and I didn't. I don't mean to drag the board or any of us through this. This was all done and adjudicated in the courts. And there's an order from the court signed, so ordered, as to a stipulation that Janet, Charlie, I, all of our children signed in October of 2023. And it delineated the final division. And we're done. As Heather just said, she didn't realize there were 300 feet there. I'll tell you who did. Robert Barish, the former head of the select board of this town of Plainfield, Vermont, knew very well that there were 300 feet there because he worked with Paul Gillies, his executor, his dear friend of decades, to build a will that he hoped would be impermeable. And so Charles would get exactly what he was supposed to get, and Janet would get exactly what he wrote for her, and I would get exactly what he wrote for me. This is all in the past, and there's no reason to revisit it. Janet, I'm so sorry that this happened and that it got confused because you thought this was being granted to you, but it wasn't. And no one ever signed this. That's the one thing that you did say, just factually, just so we're clear. We signed something in October of 2023 that was a legal stipulation and was so ordered by a justice of the Vermont judicial system. But no one ever signed this map. There was discussion of this map. Charles, I know you hesitate to involve yourself, and I love you, and that's fine. But you did say to me that you were never aware of this concept of this right of way, never heard of it, never discussed it, not in mediation, not in court, not in the stipulation. You were very clear with me. If and when you'll have to say that in a court of law, I hope you don't have to because we don't go there. Again, I wanted to stop earlier, and I'd appreciate it. Maybe we could all just stop. And Janet, if you want to take it to another place, then you can do that. But I don't see anything productive here, and I hope I haven't been rude to any of you, and including you, Janet. I'm sorry that this happened. I really am. But I cannot agree to it, and I won't agree to it unless I'm instructed to by the courts. Yeah, so that's, it's up to us. So thank you. Thank you very much. Thank you.
I would like to have a conversation with the board right now, please, and Karen. Karen.
I'm so confused. So I just wanted to say, we're here today to discuss if there are more than 2 lots.
There are more than 2 lots.
It is a major,
yes.
so it's a major subdivision, okay?
Yes.
So our job, your job today is to go through those lines that are in section, whatever it is.
430.
No, 300, we're only at 300 preliminary, okay? So you're to go through these lines,
I was trying.
right, and go one by one. And so we're pretty sure it's a major, so we just go through these things and any supporting documents that you want, you would request, and then set a hearing date. If the legal, right, that's not, it's got 300 feet of road frontage, there's nothing that says really clearly whether it has to be developed, like the zoning says you have to have 300 feet of road frontage. Doesn't say what the 300 feet of road frontage has, except it has to be continuous. It has to be, can't be, so that meets that requirement. Now, the business about the
Since
right.
it meets that requirement, what's this other 258, 3,
Right, that doesn't matter because you have the 300. All the rest of it, and that's a lot of existing.
300.
There's 398.5
Right here.
feet here, and there's 234.5 feet right here.
But this is pre-existing. This is pre-existing, so it doesn't matter that that's only 200, it's the 300 here.
Yeah,
Right.
why is that a red line that,
Because there's already a pre-existing lot right here. This is a lot, this is
okay,
Stephen Durgan's
yeah,
lot.
but
Okay.
that exists already, why?
Yes, so yes, it does. Well, I'm sorry for the disharmony in the family. And to my mind, that it should be sorted out before we have to go through a subdivision, but since our job is limited, I will go through it.
Well, I mean, it is. I'm just saying that's what we're here for, to go through that list.
Well,
Whether they want to continue to go through that list is maybe up to them and then we
The
can,
estate, I'm sure, would like to continue to go through this
Yes.
again.
right,
And so, I feel since the state is the applicant, we should do our job, and I feel also as, somebody who has to mediate very difficult relationships between people sometimes. That something like this would be best worked out before it comes before us.
I didn't think this had
Would be
any
my
to do with
preference.
relationships, that's confusing me, so that's up to someone else who seems to think it does. But I
Because a
thought it was
right
just
of, I mean,
logistic.
when we've done major subdivisions before and there were lots that needed access. They needed right of ways, but that's because, like you said, they were all cut out of one piece of land. Fowler's land being one of them, and we've seen other very difficult right of way conversations before the board. It happens, so, let's see what these rules say, yeah?
Great.
Okay. All the information required for a sketch plan application. Plus. Okay, the title, name and address of the designer, the plat. Which we know that. With location grades of all driveways and private access roads proposed by the subdivider, if applicable, the width and location of any public highways, trails or places shown. In the Plainfield Town Plan within the area to be subdivided. Contour lines at intervals of 5 feet or less of existing grades. So a map that will have to have grades on it.
Yeah, we did have that on the second page, that,
yes, there's another map that has the grades on it.
May I say something?
Please.
Color one.
I don't know if this is the right time to bring this up, but
Yeah, go ahead, Charlie.
you'll notice there are 3 lots now with my name on them.
Yeah,
I'd like to make sure that they're all combined for one.
yes,
And also, one of the lots is Charles Barish and Andrea Gould. The other 2 are Charles Barish. I want to make sure that they all say Charles Barish and Andrea Gould.
so that's something you have to go to the estate for. Because the state is the applicant.
Okay,
Again, so that's something that needs to be worked out with the applicant to make sure that that is what you're just, we can't make that
And it's
determination.
a quick question, Karen, is that a separate process to merge those into one? Because if this is a subdivision. But that's a question.
I mean, we've had these questions, we've discussed it, so what's kind of hard in a way, and there's another letter that she has sent, but if you notice this,
This is the land right here, here's Charlie's.
okay,
And
so this is what the hard part is right now, okay? This is the tax map, right, of the boundary, right, which is Charles and Andrea. However, according to the letter and from the surveyor, that they couldn't put the boots on the ground for that picture. So that's why you have, but that when they went out to survey it, the description
didn't fit.
didn't fit what was on the tax map, was that right?
yeah, it didn't fit, and also it couldn't fit anywhere.
Right.
It just wasn't, it couldn't be done.
So they ended up sort of making this because there was no real, the definition of the land is really more this than the tax map, right? The one that's,
Yes,
right,
yes.
so we started a whole little bit about that, so.
And it's kind of an aside, but just to.
Right.
To
So-
try to give.
So
clarity to
they were
everybody.
he was gonna be deeded this 5
This
acre,
area over
5
here.
acres here,
Yeah.
and this here is part
Yes.
of the stipulation.
Yes.
So we kind of just decided that this would all become one and that.
Yeah.
would become one.
That makes sense.
And that can be a part of the subdivision.
Right, and that's why it started being at 6 lots, because one, two,
Yeah.
3, 4,
Five.
5, 6.
Yeah.
But then, because of this discussion,
And also just making it all one.
Right.
Makes it 5.
so I guess we're incorporating it. I didn't think that we need, wasn't thinking that we needed to do a boundary line adjustment where we got rid of the boundary lines. That's what I was thinking.
I mean, it seems kind of unnecessary, I just don't know procedurally if that's thing or not.
One of my questions. I guess you can subdivide a subdivision after a year, right? You can't subdivide these lots into further lots until a year after a subdivision's been approved, right?
If you do the subdivision, you approve it, you write the decision.
Right, and then
You have
by-
the 45 people,
no, that's not what I'm asking you.
they have to have the map and
That's not what I'm,
6 months.
what I'm asking you is. These lots can be further subdivided when?
Well, with their current zoning regulations, you wouldn't be able to do, that's the part we're talking about with the thing up here in the village about. We said that you can only do 4, but we determined that's not legal by the state of Vermont.
Right, so then a subdivision, as a lot can be subdivided again right away,
Well, the 5-acre ones can't,
right?
and. So, yeah, I don't think that consideration for future subdivisions is part of this process.
Okay,
We're in return.
Yeah.
The list,
so yes. The contour line map we have. Typical cross section of proposed grading of driveways, no driveways are proposed.
it's existing.
So, in addition, Mary, just to make sure that this application is asking for a variance of all the parts of our subdivision regulation that have to do with buildable lots. So that's setbacks of buildings, water and sewer, driveways and things like that.
Say it again, please.
So the applicant, the state is asking as a part of the subdivision application for variances for the things, these following sections,
Okay.
because they all pertain to
Okay.
a buildable lot. And these are not, and there's no, they're not going for buildable lots right now in this subdivision
Okay.
application. So that's a variance we have to discuss
Okay.
in the hearing. So that's going to the 7 and 8, 9 and 10. The location, so 7 through 11 are all, well, we could have designs for any bridges or culverts that may be required, but there's none. Okay, so the location of temporary markers adequate to enable the commission to locate readily and appraise the basic layout of the site, so that the surveyor put markers out.
I don't know if she's completed that, I know she started the process, yeah.
So so supporting documents, a legal description of any proposed covenants and or deed restrictions which are intended to cover all or portion of the subdivision, are there any?
No.
A description of any proposed homeowners association or other form of management?
No.
Erosion and sediment control, that is usually done when we're building, so.
No, yeah.
Other or information, studies or reports required by commission under Article 2 of these subdivisions, so we'll look at that. Next,
So who do I talk to make sure that I get the lots the way I want them?
You wanna talk to the estate, you wanna talk to Heather, the estate lawyer.
We've talked about this, Charlie, I remember, that you want that, I just didn't ask Lisa to update the sketch plan for it, but, we'll have it that way.
Okay, thank you.
Yeah.
I don't know where that fits, but I think probably having the signed documents for between Cubby and.
You want those first?
I think if we're gonna approve, if you're guys gonna be approving the boundary and everything, you need to have those. I would suggest that those
Yeah,
come with,
Yeah, we would
with
be.
the subdivision.
So the way I wrote I'm not opposed to that, it's just that the way I wrote the boundary agreements is I wanted to be able to refer to the survey in the boundary agreement as a kind of a conclusive, this is what the boundary is. And I didn't want to finalize the survey until I knew that you guys liked it. So I think in order to have it signed, I'd probably have to do the survey, get it signed, and then get you to approve it
What about a letter of intent
from the homeowners or,
from Covey, like,
yeah, okay.
would a letter of intent be a big enough legal document? To say the letter of intent is, I'm agreeing to that, I'm gonna sign to this, and then the future one would be, you would sign, would have the survey in, would that work?
To give to you?
To give to the,
Yeah, I could ask them for that.
Okay.
Although I don't think you need to approve it or not approve it, and those are outside boundaries to the parcel that's getting subdivided. And
But
if
you're
you want-
saying it's a boundary, this,
that boundary-
clarification. You're saying it's a boundary clarification, though.
Yes, it's a boundary clarification, which isn't under your regulations and it's not really part of the subdivision.
So that boundary is between
But-
Cubby and what will be my property.
Right, again, because we're approving the survey and the map,
Yeah.
it is important that what we're approving is what's gonna be on the final map plat.
Yeah, well, that's kind of why I wanted to get your approval before I got them to sign it, because then I could refer to that. Your final, your approved survey as the definitive survey.
So this dotted line over here on this is, again, this area that's the old property boundary,
Yeah,
right?
I think
And
so.
then Lisa's saying this is the survey boundary. So. To me, like she had a curved boundary line and now the survey proposing a straight one.
Yes.
Right down here.
Explain how that happened,
Right, that's the.
if that helps.
Well, I mean, for us, I just wanna have a map
I
that
think the
we're
red
gonna
one is just a
approve.
contour line, I don't think it's the.
No, the yellow are the contour lines, the red is the property boundaries. These are the subdivision lines, so actually
Okay.
maybe she's actually, This is the town map, actually, these red ones are the town map, and this is the survey line. This is where the survey differs from the town plot
Okay,
map.
yeah.
So that's what, cause I see that over here, and that's what Karen explained.
Right,
This is what the town says, and
Yeah.
this is what the survey has worked out.
right,
So I guess
Okay,
I'm not,
Janice, did you say you had an explanation to that?
So what happened is that Cubby's had built their house and their sheds without taking into consideration the setbacks. And so it actually was on what is going to be my property.
Right.
And I've done everything to try to make this easy for the estate settlement, for my family, for the Cubbies. And so what I did is I gave up property so that her buildings would never be contested as being too close to the property.
See that, cause the building is right
That's
on
why it's
the
a
property
curved
line.
line, because it actually, at the road, there was a pin that showed where the boundary was, but it put their building in somebody else's property.
so,
So that was the
Darlene?
concession.
actually understood it as that was always the boundary and that it never encroached on the property. And walked it with Lisa and Janet and her husband, and Lisa thought that what Darlene pointed out was defensible as well, so that was what was adopted. What was.
It was never surveyed when my parents bought the property.
Right, and what we just have is a red line that's a town line.
And Darlene didn't
Town map.
think about it, or not Darlene, Tom and everybody, when they built that house, and it turns out that it was not appropriate.
Well, we also know that town maps aren't always accurate to
It sounds
survey
like you're
maps,
both
so.
in agreement with
Map,
with this map.
Yeah, with that particular.
Okay, so as long as the decision. so then-
It's now going to move forward with signing that, and I don't know.
What is the boundary agreement with Covey, Darlene? It's for this little thing
Yeah.
that,
Yeah.
okay,
gives
it's
the,
not the whole boundary, cause my question was, why are we doing that again? Okay,
no, so this is the town line, and this is the survey
Okay,
line, so
thank
they're.
The boundary agreement, which hasn't been signed yet, says. We've realized that the deeds don't make any sense, so what the boundary is what this survey looks like. So my idea was that we get a survey, have you guys say, yes, this is a good survey. And then we would be able to sign the boundary agreements and convey the properties. So as I understand it, like when you guys approve something, you're approving us to do something else. You're not saying that's how it is yet, it still has to happen, which is why I thought of doing the survey after. If she changed her mind and said, I'm not gonna sign it, then I think we would have to come back here. But it's fine to do a letter of intent, if that seems more.
I was
all we're doing here is
talking about what they.
confirming this is a major subdivision, we have what we need
Yeah.
with that, and then we can set a hearing date.
Right, and I guess that what I hear Heather saying is she thinks that. It's what we approve is what then they follow up by supporting documents.
I mean, and we really have no authority to say what's the right line or not, but we can say
Right.
the survey looks, that it meets the
The-
step we require.
Right,
and we'll have
Ir-
to-
no irregular lots and things like that, you know, so. I think we're moving on, right? Construction, we don't have constructions happening, so. Final,
Variances, and I don't know, that doesn't preclude a building lot in the future.
no, what
Just
it
part of-
means.
That's just what this just.
Right, so when we do the decision, the findings and the decision, we'd say, okay, no, there's no application for building. This is not a building lot subdivision, this is just property but lot division, and that if in the future somebody wants to build, they must meet these sections.
5 acres or 300 feet.
Yeah, and
Septic
yeah,
available.
exactly.
And,
Thank you.
and in the past, you have, the DRB has said, in order for the zoning administrator to grant a building permit, those designs have to be done first.
Exactly.
So
Right,
that's the condition that you have put in the past, it's like,
Yeah.
the zoning administrator cannot
Okay.
give them
give
a
a
building
building
permit.
permit
It's not a
until they
variance.
have,
In
right,
perpetuity for
Right.
like building on it.
right, so, but other DRBs in the past have not put that clarification in.
It's good to put that.
So that's
Yeah.
a good one, and that's a good one to have, because then people do have to do the things that you would have done.
Right, they
Before-
have to do that
Before I can
you
grant the
can grant them, right.
permit.
Yeah.
I have to have the letters for the designs.
Right. So for a final subdivision plat, shall consist of one or more sheets of drawings that conform with the following requirements. The Mylar doesn't need to be submitted until after it's all approved. But we do need a paper survey, large, print like this, with all of the requirements here in section 310, proposed subdivision name or identifying title, the name of the town and the addresses of the owners and the subdivider and all abutting landowners, the name, license number and seal and signature and license of the licensed land surveyor, the boundaries of the subdivision and its general location. So this is what we need for the final plat, okay?
Yes,
So that when we come to hearing, that should be pretty much what we're proving.
right,
And that's why I was saying it'd be good to have at least a letter of consent from Covey that she said, yeah, that's right, because otherwise you would have to come back, and why do we wanna go through all of
Yeah.
that again,
Yeah.
you know? Okay,
I do have the map, not this one, but an earlier one, but this part is unchanged. That she signed and said agreed. Is that good enough, or do you want me to go back to her? I
if
don't-
you've
I don't
got
have it in
one,
front of you,
right,
but that's all that it is I wanted to make sure we were talking about
right,
the
it
same
it
thing
is
before I
this,
said
yeah,
going
yeah,
That seems
yeah.
sufficient.
If you've got one that she signed, please submit it,
Okay.
yes. Okay, the location of all the improvements referred to in Article 4, including building envelopes, driveways, utility poles, none of that is relevant for this. Monuments which shall be set at all corners and angles of the boundary, so again, those need to be on the plat.
Mhm.
The site plan. Boundaries of all areas to be held in common or reserved as undeveloped or conservation land. So is yours gonna have conservation land on it? Cause those boundaries would be needed to be.
So it's in current use. My dad had it in current use. I don't know the logistics of moving forward with that after that's subdivided, because some of the parcels may not have enough acreage to meet that. I'm not sure if that.
But what about the wetlands or anything like that? Usually these plats do have areas that are, you know, like you said, it's got a wetland that's.
So you'd like a document that says that?
Well, let's look here.
I don't think you do, because we're not asking, the state isn't asking to set land aside for conservation
Okay.
or open lands.
The boundaries of all areas held in common or reserved as undeveloped or conservation land.
Yeah, so
So-
we're not doing that right now,
Okay,
so if someone was doing it later, it would be like building.
okay, so there's nothing there now.
No.
Okay. A notation stating approval of this plat is subject to the terms and conditions imposed by the DRB in accordance to the Plainfield subdivision regulations granted on the final date of the final approval of the plat, containing 2 signature lines for the endorsement by 2 DRB members. Any additional notations required by the DRB, which references specific conditions of the subdivision approval. So we can have specific conditions.
I can submit to you the letter from an engineer talking about the fact that it is a complex wetland.
That's not, speak up a little bit.
I can submit the document from the engineer about that access from Fowler Road, that it's a complex. I don't know if that's useful, but I'm happy to get that to you.
Anybody that's party to the hearing can submit. Anybody that's gonna be a party to the hearing
Okay.
can submit evidence, and that's always helpful in determinations.
So other supporting documents to be submitted to the DRB with the final plat is written evidence of application to approval by all local, regional, state, and federal agencies having jurisdiction over the project, and written evidence of expiration of all appeal periods. I don't think there's anything relevant there, right?
We are getting a state water and wastewater permit, you need one for certain subdivisions.
Oh, you do?
Yeah, so Chase is getting that for us.
Okay, so there will
So
be.
that's in process.
Okay. A certificate from a consulting engineer approved by the select board. To the satisfactory completion of any improvements required by the DRB, or in lieu of their inadequate performance bond or equivalent surety. To secure completion of all improvements required by the planning commission, but I think these are things, again, have to do with building mostly. That has to do with like roads and slopes and grades and drainage and things like that usually, right, Karen? Yeah, so I don't think that's relevant. A legal description of any proposed covenants, easements, or deed restrictions which are intended to cover any or all portion of the subdivision, so if there's any of that, you want to
Right.
submit that.
There is none this time.
Okay, any other legal documentation that the DRB deems necessary for the administration of the enforcement of these subdivision regulations. So, you know, there's that number 4 right there says there's this internal conflict we're hearing where there's something that everybody signed, but then one of the interested parties is saying that.
Yeah, I really don't think that's under your jurisdiction. I mean, I think you guys could argue and discuss with Karen whether you can require something more than road frontage. In my opinion, you can't under the subdivision if it's there. But I don't think you can require a particular map or a particular easement, you know, I think you can only. I
Take
think
what
it's-
you've submitted.
Yeah, just look at what we've submitted and say yes or no.
Okay.
And that is one attorney's opinion, because I have an opinion that is from an attorney that is different than that. In terms of approving the subdivision with a portion that cannot be accessed is not something that would be recommended. But again, that's up to the DRB. Then Karen, did you submit a letter?
Yep.
To them about the.
Yep.
The letter from Heather?
No, I did not spend the land from Heather.
So I would bring that, which is the letter that says that the right of way will be included in the deed from Heather. And that it was already approved, and it doesn't need to have a specific vote because it's been approved by the estate and it will be included in the deed. You got that? Did you get that?
Yes, I did.
I didn't know you didn't submit that. I can put it.
I
I'll get that. to
I
you.
only thought I was just submitting the one that you had sent earlier.
Okay. I'll get that to them.
All right, so board,
Okay, well, yes. It's a,
Do we have to
we
have any
move to
motion?
set
we
a
need to
hearing.
set a hearing date.
I guess, when would be an appropriate time to set a hearing date? I mean,
Excuse me,
yes,
don't we need to have a motion on that it be a major subdivision?
Yes,
Okay,
correct.
you wanna,
Yes.
someone move that?
I'll move that this is a major subdivision.
I'll second that.
All right, all in favor?
Fine.
Aye. So it is a major, we recognize it as a major subdivision and
Can I ask
We-
a question?
sure,
So the regulations seem to say that there's gonna be another hearing with a preliminary survey and then a final hearing with a final survey. But Karen mentioned that maybe there could just be one more. So when we're thinking about scheduling, I'm wondering what I need to have prepared with the surveyor. Are we going straight to the final one? I need
so
time to have-
usually, I mean, in the past, you know, this is like informational, what do you need?
Right,
And then you come with all that information before the town and all interested parties, and we hear all interested parties' comments. And take all of that and make sure that you have presented everything that's needed. And then you come back with it, we look it over and sign it. And then you bring in the Mylar, that's how it's been,
okay.
so.
So you don't usually have a third hearing. We have one more hearing where I have a preliminary one, we talk everything through, then I go execute and get the final one and show it to you.
Come back with it.
Is that right?
We've done smaller subdivisions all in the same swoop. If we got everything together, so, I don't think we need to have, if they come in with all the information necessary and there's no question, you can do the second,
final.
together.
As long as you've got that survey map, yeah, well, you don't have to have the Mylar, but you gotta have what's gonna go on the Mylar. All the information on the, that would be on the Mylar, all the surveyor and the spot for the signatures and all of that has to be on the piece of paper.
Yeah. Okay, great. Does the, it looks like the contours only had to be on the sketch plan, I don't think we need that on the final, right?
No.
Okay, that was just here, okay. And so,
I think again, that's often, and when you're building lots and they want it to be slope and grade, because that's important
yeah,
in development,
right,
slope
okay,
and grades,
yeah,
so. I don't think it needs to be, I don't think I've seen final plats with it, or maybe they do.
No, they don't, no,
Okay.
normally we just have a good old survey.
Yeah.
Good old survey, some, yeah, usually it's just a good old survey.
okay.
Yeah, anything,
So apart from the possible easement issue, you're not seeing any flags, I can probably tell the surveyor, let's go ahead and finish cleaning that up, that final. And if that does come up, we could figure that out later, but.
Right, you know, and your variance for the road frontage, I think is pretty straightforward because it's already pre-existing.
Yeah,
So, you know, we can't really change that.
right, Okay, thank you.
Karen, do you want to forward that to me or do you want me to do it separately?
Why don't you do that? Okay.
So timing wise,
Yeah.
you know, as far as getting that information together, is the December, you know, month from now reasonable, or would January be a better timing for that?
The thing that's gonna be hard, okay, is for the December 11th one. We're gonna set a hearing date, we've set a hearing date for Devin Lynch
Fine.
at 7:10. And in subdivision regulations, I have to send out all the hearing notices and stuff, so we have to pick a time. And so that is, that's the hard part when I'm organizing this.
Can
Plus
you
it-
wait till January to do this?
Yeah.
All right,
Okay.
let's set it in
Right,
January.
and then we can discuss about the other one that's in the pile.
So what day would that be?
That would
It's
be
the second Wednesday of January.
January 8th.
Okay,
And we put that on the docket first.
yeah, you would be first on the,
I like the 7:10 just in case, like.
Yeah.
People aren't. It gives you time to get your head into zoning, or for me.
Okay, so
January 10th, you said.
January 8th. Alright, so I'm.
Thank you.
How do I send information to you? Send them-
Well,
She sends it all forwards at all
You
times.
want me to forward all the stuff? I
Yeah,
mean, okay.
Or you could just send it to all of us.
Or, yeah, I don't know if all of our emails are, her email is,
Through you.
so.
Okay, you prefer through me?
Yeah.
That's fine.
Come through you.
Okay.
Okay.
I'll just say please forward.
Everybody.
Do we need a formal motion?
Yeah, we do,
Okay,
yeah.
I move to set a hearing for the major subdivision on January 8th at 7.
Second.
10 and then all in favor.
Aye.
Aye.
Aye. It's a unanimous support. Well, I hope things can be resolved.
See,
Thank you for your time.
Yeah.
I know what it's like sitting on that side of the table.
you wanna join?
We need
Can you
another
send
DRB,
members?
we have, actually, this is a 5-member board. We look like 5 members, don't we?
It probably would not be quite as challenging. I don't know if any of you were here.
Yes.
We had a restraining order
Yes.
against a select board member to protect me. Because she.
I remember it well.
And
When was this?
It's-
What year? When,
Bob died in 76, 97, so it was 97 through probably 2003, probably. And that's when we started having to record all of the meetings. We had to have Paul Gillis, the attorney, was present at every meeting, and a police officer.
wow. I feel wild and crazy.
It was.
Well, it's always wild and crazy. Come
I know,
on.
we just haven't, I know, we continue to be wild and crazy. We're the wild east.
So,
It's a hard job, all of you.
hi, Mark. Karen's story is actually Karen Smith.
Oh, I know.
So
this
we have
story.
another.
Yeah, we do.
Yeah.
No, I know
Wait.
that. Hi. Yes, hello.
Hi.
Yeah, thank you all very much for my goodness, going through this little saga with us. I apologize for the emotional content in the whole evening, but thank you very much for going through all this. So if I can ask, because some of the audio was breaking up for me, and I just switched to a different device because I could tell maybe I could hear you better. Hi, Janet, there you are. I don't have video, but I can see you now finally. Hey, Ray. So anyway, so I know Charles wants to make sure that we get those winning names. He'll get that done with Heather. If I understood it properly, you're approving the map that the executor brought forth, since they're obviously the applicant. And then, of course, there'll be a hearing and there'll be more conversation. I just wanted to understand, is that how it's resolving? Did I understand that?
Because we have
So,
one more thing.
The DRB has
Excuse
this,
me.
there's gonna be a hearing on January.
Right.
eighth.
I got that, Karen. Yep. So, but for now.
Hi,
this-
Charlie. Hi, Rob.
Okay.
Bye.
Send me
All
an
right.
email with questions, Mark. You have Plainfield ZA, okay?
Yes, I do. Yes, I'll find you. Yes. Good to see you.
Okay, send your comments that way. It'll be
Sure.
easier.
Absolutely. Okay. Thank you all very much for your patience and your help and input, all of it. Thank you very much, everyone. All right. Bye-bye. Have a good
Yeah,
night.
you're welcome.
Well,
Thank you.
Have a
good
good night.
night.
Thank you.
Thank you.
Night, Charlie.
When we have our hearing, we go through subdivision, Article 2 sketch plan.
Mhm.
So when we go through the hearing,
Mhm.
we consider all of this here, okay?
Yeah.
And then here,
Yeah. Yeah, I know.
location of existing. Yeah, what do you want to say?
No, I was thinking. Just, I think in the meantime, it would be helpful to know what's in our purview and what's not.
Well, here we are again,
I know,
you know, and the reason they go before us is because, I mean, the thing is, we have to stay within the scope of our authority. And additionally, we are judicious, so things aren't always black and white, but if the, and my question is, you know, she's presenting evidence that there's a conflict of what's being submitted, and we even had a lawyer submit 2 different documents. So like, why, we are in the middle of this.
Can you sign this as granted? And you granted it the last meeting, which was
10, oh, I have to use pen.
10,
10-9.
yeah.
Sure, yeah.
So, you know, I understand that we have, but we've been submitted by the applicant 2 contradictory information. And so, and we have, somebody who's a part of the estate who's saying, giving us evidence that there's conflict. So how can we in our right mind judge on something? Make a decision on something
Yeah.
that's being given to us that's.
I don't know, do we discuss all of it, or meeting? Or?
Yeah,
Yes,
good idea.
Post.
Right, yeah, I don't
So
think,
we understand.
these are the questions I have, but we
Yeah,
can
yeah.
discuss it later. Or at the hearing, because I think it's an appropriate time to discuss it.
I added it.
Yeah.
Okay,
Yeah,
so,
here it is.
so everybody's wanting a variance. Everybody's wanting something.
What happened to the halcyon days of no meetings or any?
Yeah.
Okay, so this came in, this, by the way, happens to be Sarah Albert's old property,
Oh, okay.
okay? And the people who purchased it. And I don't know when the house was built, but the house was built within the setbacks. So I don't know if the house was built before before 1970, when we started having,
I would think.
Setbacks for house,
yeah.
probably, it's gonna be a long time.
So they're asking for a variance because the distance between their house, here's the 50-foot setback right here. Their house is mostly,
Hold on, before you go.
Okay.
I can't see that, so I'm gonna.
do the other one.
Find my.
Okay, got it.
It must be in here.
What are you looking for?
The agenda where I'm writing my note. Go ahead, when you're ready.
Okay, I'm ready.
All right,
Okay, so the house is well within the setbacks, in fact, most of it. And so these little hash marks here is where they want to put their additions. One is a carport and one is I think it's a
oh, right, and I saw the neighbors saying they have no problem with
right,
it.
and they're darn close to the 50-foot too, but anyway, so the thing is like different DRBs have ruled this differently, and you guys can decide, like, past DRBs would say, oh, this is too many square feet, that's putting more into the setback.
Right.
Other DRBs have said, oh, you just drive a straight line across where it's already encroaching and go from behind,
Yeah,
so,
which is what they're doing right there.
Right.
That was me.
so, but
What's the setback here?
Yeah,
this is the 50-foot one, this one right here.
But
This
they're
is-
not, so they're not making it, what about, here.
The-
They're not making it any further.
closer,
But
but
they're
I'm
not-
just saying that other DRBs that I've been with have said because you put more square foot.
Oh, yeah.
Yes, in Plainfield,
No, because I've been on the DRB since
No.
there've been a DRB.
No,
It was
they-
a Z, it was a
was
zoning
it, oh, it was a ZA,
board.
well, the other one, this, it was, there was two very conservative Republicans on it. And they would do, so I just wanted to tell you, other DRBs have ruled differently than the current one. So,
Yeah, Mary.
What is the setback from, and what's this dark line? Is that the
that's property
property?
line.
Yeah.
And what is this line?
That's the, that's the.
Road?
That is, okay, so
Is that the
back in
road?
the good old days. They used to let you have 50-foot frontage on, in the forest and ag, so that is a 50-foot frontage. That goes all the way back. To the big lot. And so her driveway, Sarah's old driveway.
Is part
Was
of
a
that?
right of way on this 50
Okay.
foot.
Thank you. Now, what's the setback from this, whatever this is, to the here?
It should be 50 feet.
It says here, this is 50 feet,
So
and
that's-
that's much longer than this.
Did they ask for the variance on that one? 'Cause I haven't actually looked at it.
They asked for variance. I read it actually.
Yeah, I figured that out. I have it open.
That's the letter saying it wouldn't be a problem.
Is that the wrong?
Yeah, that's the Karen one.
They're all confused now. Yeah. Right.
Okay, image not to scale, all or most of the proposed carport is within the 50 feet property line and requires zoning variance. Approximately 9 feet, 95 square feet of addition is within the 50-foot property line and requires zoning variance. So the carport, I believe, is the one.
Probably the one that's a variance.
They're both asking for a variance, but the carport, which is the one on the right, Mary,
Yeah,
the square, is only 9 feet,
from the property line?
9 feet. No, it's only, it's only 9, so it's 40,
Okay,
49, 40, 50, you know, it's like
41,
41 feet, not 50 feet. So they are,
okay.
okay, and then
That's
this
the
one,
variance.
this one is within the 50-foot setback
Yes.
entirely.
So it's, the variance is for this.
Both of them.
Why do we
This
need a
one.
this variance?
Because
for
it's
that?
also within the 50-foot setback.
Oh,
Yeah.
Because the house is within the 50, so this is the 50-foot setback here, right?
Yeah,
And they're all of it is within this setback.
Okay.
This one is only a couple of feet into this setback from the road. From this property.
Oh, I was confused, so this is 50 feet from this line.
Right.
Yes.
I thought this was a measurement,
Right.
and it was, okay.
Right, so what they're saying is
Yeah.
here's the
The
50
part of
foot,
this one is.
all of that one.
And all of this is.
Right,
yeah,
so, but this doesn't make,
Got it,
it's,
doesn't encroach further.
right,
than that 50 feet.
this,
Maybe the
and they're
setback.
saying that 50 feet over here, this is 9 feet into this 50-foot
Yeah.
here. And, we could say, oh, you gotta build it 9 feet shorter, but it's approximately 24 by 24 for a carport, and I'd have to be an engineer and know if you can make it.
Okay, so the only thing that really is a stickler on this is. The last
job, we can see the one.
So the only one that would be difficult on this one would be, is the need for the variance created by the applicant?
No, it is not
Okay, I'm just saying that would be,
a question.
could you put the carport somewhere else? No,
No.
no, can you put the addition that's the, whatever it is,
Dining
the
room.
dining room?
You could put it on,
Make it worse.
or you could, right, and
Yeah.
you know, you would, The addition,
You
it
got
would
a
be,
porch there.
right, you really couldn't put it on the backside because there's already a porch there.
Right,
Honestly.
But they could turn the porch into the dining room.
It's true, but
I'm just saying that
Yeah, yeah.
I want you to be able to say with I'm
A straight face?
Yeah, it was, I mean,
Well, no, this is just for us to consider, right?
Right.
But we've got, like, the neighbor says they're fine.
right.
Right, and for me, that's huge.
So, you know, we have been a pretty, you have been a pretty,
Lenient.
thank you.
I wouldn't call us lenient.
I think you've been very fair.
Thank you.
I like that better.
Fair is
Um,
good.
I retract what I said.
I really feel like you're making decisions that are well within acceptable variances, because why make a 5-acre lot for the last thing and you know this, so I think you're being really very reasonable. Just some boards do not like give variances. They
Well,
just-
Sarah Albert was on this board for a while. And, you know, she helped create these zoning regs, and she was a letter of the law kind of person.
Yeah.
And she did not believe in giving variances. And she said, why should we be giving variances? And I said, because individual situations don't meet the rules, and we need to abide by the spirit of the rules, not the letter of the rules. Letter of the law, and she actually came around on that one with us.
Should we ask her what she thinks of this
She's
plan?
done.
I know,
She was
No,
all
this
good
is-
now. She's had.
I know.
And
Zoning
Sarah did
about failure is much harder than zoning plan. So
And then you go
anyways,
through
so
the
when do we
design.
want to make this hearing?
Do we wanna do this in December after?
I personally think that you probably,
You wanna turn off the mic?
no, I think we could do this one. The thing that's really hard is determining how long the first one's gonna be.
Can we do
Well-
this one first and then Devin's
We,
after?
but we made a motion that to.
Yeah, I mean, what if we said it at like the half hour, you know, so it's not as far apart as this one, if it starts later, people will be here.
Okay, so like have one at 7:10 and send one at 7:40? Or 7:30?
7:30,
7:30, I don't think, I mean, if he brings in the documents,
it's kind of either gonna happen,
or it's not.
well, if he brings in the documents, it's gonna be longer.
Yes,
If he doesn't, it will probably be shorter.
Yeah, but if Chase and Chase does all that stuff, it will be,
It'll prove to us whether it's permittable or not.
yeah,
Yeah.
right. So
You
I mean,
know,
if he gets, Chase and Chase is very good.
And if.
That's what we need.
Yeah,
I
we
feel
need,
comfortable.
that's what we needed from his mother, we needed plans, we needed to see if it was possible. And if he has the resources to build a septic system and a little house for himself on that corner, God bless him, you know?
So anyway, so needless to say, so would you say 7, you wanna go for 7?
45.
No, 7:40,
7:40,
It's 7:40.
okay.
because I don't really wanna sit around for
Yeah,
a 10-minute
that's the thing.
hearing for more than 20
Right.
minutes, that's 20 minutes.
I think it's better to have. Do this one on the Devon Lynch one versus, cause I think that next one's gonna be,
Yeah, this one doesn't seem that contentious,
no.
so,
You never know.
I know, I feel like
And they're
that.
responsible for notifying the neighbors, right?
Right. So I have to put I have to get on point for doing all the notifications, and so that when, you know, so when I
So
wrote that.
that one's gonna be on the December,
Was it the 10th?
The 11th,
11th.
so
It's
move the hearing for December 11th, 7:40.
yep, for the, it is not on here. For that
Variant
variance.
for
Variant.
setbacks.
Yeah.
Enforcement.
For,
I'll second that. Since there's only 3 of us.
yeah, that's it.
Well, I would, you know, my
I-
first rule of a chair's job is to kind of be the moderator and only
Right.
vote and make motions if needed and break ties. That's how I was taught.
Yeah,
But we're such a small board.
We
You know.
certainly are.
All right,
So,
I seconded,
I
and
heard that.
and you, All in favor?
All in
Aye.
favor? Aye.
All right, so we've got our work cut out for us.
Yeah.
Okay,
All right, so I'm gonna, in any other business?
Yeah, business.
this is.
No, that's not sustainable.
No,
That's not
no.
sustainable, Mary. So I'll take a motion to end our meeting tonight.
Oh.
Second,
Second,
all in favor?
Aye.
All right, Nathan, if you're there, I'm going to be turning off the Zoom now, so thank you for participating. If you're there, good night.
okay, now, how do I get a copy of the recording?
That's a Kristen question. Usually it gets put on the. You go to YouTube, it has to be put up on